Okay, good morning, everybody. We were talking about stealing goods in order to perform mitzvahs. And so we learned that if a person steals um, a lulav or any of the arba minim, as long as it's not in the hands of the original gazlan, it's still kosher, but there's a deliberation in the poskim whether or not you're allowed to make a bracha on it before doing the mitzvah. I wanted us to take a look at a seif in Shulchan Aruch in Orach Chaim that talks about sukkah gezula, a stolen sukkah, because there's a lot of different permutations in this halacha, and it's a good review of some of the different halachas of gezela. So the first statement in the Shulchan Aruch is sukkah gezula keshera. A stolen sukkah is still kosher. Now, as the Mishnah Berurah points out over here, he says, Ein halashon medukdak kolkach. The language here of saying that calling something a stolen sukkah is not really that accurate. Daha darshinan midichsiv chag hasukos taseh lecha limaute gezula. Because the Gemara says explicitly that when the Torah says that you shall make a Sukkot festival for yourself, those words for yourself are specifically to the exclusion of a stolen sukkah. Elarot Salomar, the Gezula Kahai Shetokaf al Chavero Vahotzio Keshera. But rather, as we'll see, it's only a specific kind of stolen sukkah, as we're going to enumerate. So, Ketzad. So, what's the illustration of a kosher stolen sukkah? Im Tokaf al Chavero Vahotzio Misukaso Vigazla Viyashav Bayatza. It's only in this case. My friend builds a sukkah in his backyard. He's my next door neighbor. And I go over next door and I see him sitting there at his table in his sukkah. I pick him up forcibly. I throw him out of the sukkah and I sit in his chair instead. And I have a piece of cake and I make the bracha. Was I yotzei the mitzvah of sukkah? Yes, I was yotzei the mitzvah of sukkah. Not a very nice guy, but I was still yotzei the mitzvah of sukkah. Why? She'ein hakarka nigzeles, because real estate is not subject to theft. In other words, it's still the sukkah that I didn't steal anything. In other words, I've committed an act of violence. I forcibly removed the guy from his property. But if I sit in your house, it's still your house. I haven't stolen your house from you, right? So the point is that you're yotzei the mitzvah of sukkah because it's not a stolen sukkah. It still belongs to my friend. I can fulfill the mitzvah of sukkah with my friend's sukkah, so I fulfill the mitzvah of sukkah. Now, what I did was an aveira. There's no question, and like the Mishnah Berurah says, D'chol ha'mechuber lekarka hareu kekarka. Anything that's attached to the ground, like a sukkah that's built on soil, is like the soil itself. V'harehi b'cheskas be'aleha harishonim u'cheshu'ula damya lididei. And basically, it still belongs. The title on that sukkah and on that piece of property still belongs to my friend. And basically, I've just borrowed it without his permission. So I can still fulfill the mitzvah of sukkah. And like the Shulchan Aruch writes, she'ena karka nigzeles. So then the Ramah says, mihu lechatchila lo yeshev adam besukas chavero shelo midaito. However, lechatchila, a person should not sit in his friend's sukkah without his permission or without his knowledge. In other words, you shouldn't just go into your neighbor's sukkah when he's not at home and sit in it without his permission. Kol shekain im daito legazla. And certainly that's true if your intention is to appropriate it and to steal it from him. So here the Mishnah Berurah writes, the reason why lechatchila you shouldn't sit in your friend's sukkah without his permission is he writes, Shema Baal Hasukkah hu makbid al zeh. Shelo yireh chavero es asaka v'es achilasa b'lo yidiyasa. He says, because maybe your neighbor doesn't want you to sit in his backyard and see, what he's doing in his own backyard and in his own sukkah. Maybe he keeps private things in there. Maybe he was a private person. And therefore, it would not be appropriate to make a bracha when you sit in someone's sukkah without their permission. He says, what you are allowed to do is you are allowed to sit in your friend's sukkah when he's not around. The only thing that you're not allowed to do is just to barge in and to intrude on his privacy. But if he's not around, he says that he quotes the Taz, who says that if your friend is not home, then you are allowed to sit in his sukkah, lo yakpid al zeh, because we can assume that your friend is not going to mind. Because people are happy that people are using their property for a mitzvah. So this is, by the way, we saw this halacha when it came to tefillin as well, that there is a halacha in Hilchos tefillin that if you see your friend's tefillin in the Beis Medrash and you need a pair of tefillin, then you're allowed to put on his tefillin. However, we did see that there are those who are not happy for other people to wear their tefillin. But as a general rule, we assume that people would be happy to share their property so that people can do a mitzvah. He says, if, however, it's possible that the owner will come home while you're sitting there in his sukkah, even though when you enter into his backyard, he's not home, but he may come home at any minute, lo yikane shalomi dait, then you're not allowed to go into his sukkah without his permission. Ki efshir shabal habayis yitbayesh likanes v'lechol o lasot esek acher b'fanav, because you might be causing the balabayit, the owner, to not want to come into his own sukkah, because he may be a very private person, and his attitude may be, I'm not interested in sitting in my sukkah with my neighbor in there. I'll wait till he leaves. And then you're actually doing something which is halachically incorrect, which is you're precluding someone from sitting in their sukkah. Kasav b'bikurei Yaakov, dimnatal reshus me'ishto shel chavero k'sheinu beveso, nira dimahani dekeven de hirshate ishto mistamalo yakbid al zeh. And the Sefer Bikurei Yaakov writes that if you go over to your neighbor's house to ask if you can sit in the sukkah, and your neighbor is not home, but his wife gives you permission, then that's also acceptable. And the reason that that's okay, and remember, we saw this before, we saw that there are certain instances when you are allowed to rely on the wife, and there are other instances, like by Hilchos Tzedakah, where you're not allowed to rely on the wife. But here, since the wife gives you permission, so then you can consider yourself covered, because especially since the guy's not home, there's other stuff to rely on as well. Okay, so lechatchila, don't sit in your friend's sukkah unless he's not home and won't be returning home. There's no possibility of him returning home while you're there, so then you're allowed to. Now, he also points out, you also are not allowed to build your own sukkah on someone else's property without their permission. And you might argue, what difference does it make? He's in Florida, he's not going to mind, and he's got a huge piece of property. Still, you're not allowed to do it. And the same thing is true on public property. You're not allowed to build a sukkah on public property. Now, here too, the Mishnah Berurah comments, and by the way, and then the Ramah says, Mihu b'di'evid yatsa, but b'di'evid, you're still yotze the mitzvah, but lechatchila, what you're doing is improper. And the Mishnah Berurah quotes the Magen Avram, who says, V'tzarochim, shenahagu k'tzas la'aso sukkah b'rishus harabim. There are people who do this. They build their sukkah on public property, or they'll just go ahead and take liberties with in the parking lot without asking the landlord, and they'll just put up a sukkah. Ve'im timtzalomer dechol Yisrael mochalin mikol makom yesh la'akum chelik bahem. And the Magen Avraham says, I don't understand what right people have to do this, because even if the Jewish members of the community will give their sanction, but what about the non-Jewish members of the community? What right do you have to take the public area that is publicly owned and allow, and just take liberties and build a sukkah? Vehela da astra mitam ze laso sukkah b'rishus harabim da'akum bevadei lo machli. And the Magen Avram's conclusion, therefore, is that you're not allowed to build a sukkah on public property because the non-Jews are not giving their sanction. Va'afta b'di'evet keshera, and even though b'di'evet it's still kosher, mikol makom lo yivarech aleha da'havi bracha levatala. But you're still not allowed to make a bracha on it, because you shouldn't make a bracha on something that is not lechatchila. And he says that it's even a bracha levatala. Uve'el yerabba kasav de bracha levatala lo havi ayin sham sheherich bazeh. So, and the El Yerabba disagrees and says it's not a bracha levatala. And ve'al kein im ein lo acheres mutar levarich aleha. And therefore, if there's no other option, you can make a bracha on a sukkah that was illegally built on public property. V'chein mitzadei b'sefer Maimer Mordechai lahakel, and this is the opinion of the Maimer Mordechai. Uvetshua sheol meishiv simin kuf chav ches derechov shelifnei habayis heim shelo v'lo mikri rishus harabim. And there are even those who suggest that if there's property that's in front of your house, like a sidewalk, it might have some halachic status of belonging to you in some way, or at least rights of access. Ubifrat hechi sheyesh lahem document misar ha'ir sheyesh lahem rishus lasos eruvin v'sukkos ein lefakbek bazeh. And this is certainly true when the government issues permission to make Jewish structures, religious structures on public property. There are some municipalities which will grant permission for Jews to make a sukkah in the park or to make an eruv and things like that. And so when that takes place, then you would be allowed to build a sukkah on public property. Okay. Now,
Rabbi, just getting back to the about the building of sukkah. So what about the situation where often Jews find themselves where they're living in an apartment building, they want to have a sukkah, maybe most of the building is non-Jews, and might be a site that they don't want to see this big sort of hut in front of their building or whatever, but the Jews that are living there want the sukkah. So what would be the approach there then, really?
They would have to get a permission from the homeowners association or from the landlord in order to build it. You can't just put it up on your own. If it's on your own balcony, if it's on your own property, that's fine. But if it's in the public area, in the parking lot, or some other part of the property, which is shared property, shared area, then you have to get permission either from the homeowners association or from the landlord. Okay. So then the Rama writes, "V'chein lo yikatzitzu Yisrael hasakach ba'atzmam ela yiknu osam me'ovdei kochavim." Furthermore, you shouldn't cut down schach, let's say, from let's say a forest that may be owned by a private individual, because who knows? That's still called stealing, and you're not allowed to steal schach, just like you can't steal the arba minim. But what you should rather purchase it from the Gentile. Okay, and what the Mishnah Berurah is suggesting is purchase already cut schach from a non-Jew, because even if he stole it, then by him transferring it over to you, at least it'll become your schach. Now, the whole gezel ein osen mimenu sukkah lechatchila. You're not allowed to make a sukkah lechatchila, at least from stolen property. V'im gazal eitzim va'asamehem sukkah afal pi shelo chibron v'lo shina bahem klum yatsa. If you stole a sukkah, if you stole wood, I should say, in order to build a sukkah, and you took these planks and you hammered them into the walls of your sukkah, what you did was obviously usher, because you stole the lumber, but b'di'evid, you're yotze the mitzvah of sukkah, like, and the reason is takanas chachamim she'en lebal ha'etzim ela demei etzim bilvad. And the reason is because even though normally when you steal something, the object still belongs to the owner, but if you'll recall, we learned that if you steal a large beam and you build it into a structure, the rabbis did not require you to dismantle the structure to return the beam to the individual, but you only have a financial debt. And the same thing is true when you build a sukkah out of stolen lumber. The rabbi said you become the legal owner of the lumber so that you fulfill the mitzvah of making your own sukkah, but you have a financial debt to the person from whom you stole the lumber. Aval im gazal sukkah ha'asuya berosh hasfina o berosh ha'agala v'yashav. But let's say you steal an entire, let's say, portable sukkah that a person puts on a boat or on a wagon. You know, they have these portable sukkahs. If you steal the whole sukkah, then you have not acquired the sukkah. Lo yatsa, you're not yotze the mitzvah. And the reason why you're not yotze the mitzvah, like the Mishnah Berurah says, is dichsiv chag hasukos taseh lecha shivas yamim. You have to make for yourself a sukkah for 7 days, limuute gezula, and that's to exclude a stolen sukkah. The lo havi lecha, it's not yours. Meaning, I can fulfill the mitzvah of living in the sukkah if I sit in my friend's sukkah, because that's a borrowed sukkah. But if it's stolen property and doesn't belong to me, and I have no permission to use it, so then I have not fulfilled the mitzvah. Umashma midivrei hamagin Avram da'af acherim sheyashvu ba gam kein lo yatsu yedei chavasam delo havi lecha. He says, and it seems from the language of the Magen Avram that not only is the ganaf not yotze by sitting in the sukkah that he stole, but even other people are not yotze. He says, but it's not clear to me whether that's true. Perhaps other people would be yotze. And you see here, the difference between lulav and sukkah is lulav has to belong to you, but a sukkah doesn't have to belong to you. It just can't be stolen property. So therefore, the Mishnah Berurah is not so clear on perhaps a third party who sits in a stolen sukkah might be yotze. And then the Ramah writes, V'hu hadin im Ruvain bana sukkah bekarka Shimon. Let's say another illustration. Ruvain builds a sukkah on Shimon's property, and he does it without permission. The Shimon takath es Reuven v'gazel sukaso habenuya bekarka shelo. And Shimon basically kicks Reuven out and takes control over Reuven's sukkah. Lo yatzaba. So he says, in that case, Shimon has not fulfilled the mitzvah of sukkah, even though it's his property, but the actual wood structure is actually stolen. And like the Mishnah Berurah points out, V'lo dam yelahanal b'sif beis dahasam hakarka b'cheskas be'oleha omedes ve'ena nigzeles v'chol ha'mechuber lekarka hariyu kekarka. He says, normally, anything that's attached to the ground is part of the ground. And so you might want to argue that this sukkah belongs to Shimon because he's the owner of the property. But he says, no, ma'she'en kein hacha lo kaima hasukkah bekarka de Reuven, im kein lo gazel ela ha'etzim v'lo hakarka v'havi gezula. He says, but no. He says Shimon, who's the landowner, is stealing the wood of Reuven, who built the sukkah, because Reuven had no right to build the sukkah on Shimon's property, and as a result, the wood that he put together and put on Shimon's property really is not part of Shimon's property, and as a result, if Shimon were to go and sit in it illegally without the permission of Reuven, then he would not be fulfilling the mitzvah. Lo yatzaba ve'in kan takanas hashavim hol v'lo tarach bo v'lo hotzi aleh hotzos. And there's no such thing as saying that Shimon is the owner of the wood because he didn't put together the sukkah himself. And so if a guy builds a sukkah on my property and I go ahead and I kick him out and I sit in it, I'm not yotzei the mitzvah, even though it's my property. All right. But if Reuven gives me permission and we work out a deal that he can have his sukkah on my property and I can share the sukkah with him, so then obviously that's the best of all worlds. Okay. So a lot of different permutations on the law of Geneva over here that I thought was interesting. Okay. So let's go back to the Imrei Yaakov. Okay. Let's see. Okay. So we'll just take a look at some of the Imrei Yaakov over here. We had said that you're not allowed to enter into a stolen piece of property without if a piece of property was stolen, like a stolen house, you're not allowed to enter into it. And that's true even if it changed hands multiple times. And we also said that you're not allowed to be yotzei a mitzvah with stolen property. And on that, so entering into a stolen house, the Imrei Yaakov says that the example that the Rav Shulchan Aruch gave is going into that house to get shade, or going into the house to protect yourself from the rain, protect yourself from the elements, essentially. So near the dafka b'chi hagavna shemators kenisasu lehanos mehabayas. The only time it's usher to enter into a stolen property is when your intention is to benefit from entry into that property. Lahagen mipnei hachama v'hagashamim, to protect yourself from the elements. Ula'afuke imatoris kenisasu avor siba acheres. But that's to the exclusion if your intention in entering the house was for some other reason. Afshuhu yodea shabayis hu gazul. He says, even if you know that the house is stolen, mikol makom mimenu nichnas ba kedei lehanos mimenu mutar. If your objective is not to benefit from the protection of the house, it's permitted. Let's say I need to speak to somebody. I'm not going into the house in order to benefit from it. I have someone that I need to speak to. V'chein mashakasav de la'avor b'sadeh gezula asur, ma'rinami b'chiyai gavna sheyesh lo hana'a mizeh kamo kigon shemikatzer darko al yedei zeh. Similarly, walking through a stolen field, we said, is usur only if you benefit from it, such as it helps you create a shortcut. But if walking through the field does not provide you any benefit, then there's technically nothing usur about walking through stolen property. Okay. And then we said, as far as mitzvahs, even if you're not sure if it's stolen or not, you're not allowed to use anything that might be stolen. And this is codified in Shulchan Aruch and Siman Taf Reish Mem Tes, where we talked about stolen lulavs. Wrote Salomar, and that means the Sham Kasav Harama Shelo Yikatzeitza Yisrael Ba'atzmo Echad Mehadalad Minim Shebelulav L'Tzorach Atzmo. There, the Rama writes that a Jew should not cut any of the Arba Minim himself from a forest, because the forest may be privately owned and therefore you may be stealing the property. Mishum de karka in an exeles, the stam kusim goes le karkaim. V'yavo bigzela liyado ad kan devar, because who knows who holds the real title on that property, and therefore it might end up being this might be stolen property, and it's coming into your hands through an act of thievery. Ubir ha'inyan, to explain what that means is, shelo yikatzeitz ha'yisrael be'atzmo mehakarka shel hanochri afilu im hanochri nosin lo rishus. And the way that the Meforshim explain it is that even if the Gentile gives you permission, you should still not cut the aravos, let's say, from his bush. He says, why? Mishum dechashinan shema gazal hanochri yasakarka, because in the old days, when there was a lot more lawlessness, who's to say that the current occupant of that property is the legal owner of that property? So therefore, just because the non-Jew gave you permission doesn't mean that he's the legal owner. The stam akum goes lekarkehe. And as the Gemara says, because most Gentiles end up stealing property and just end up squatting and taking things for themselves. Now, this is not true in the modern world. I just want to clarify that. So we're going to see how the halacha changes. And since real estate is not subject to actually being stolen in the conventional sense, it's only a person who actually cuts an item from the property, such as taking a fruit or a branch, is the true thief. Lefichach lo yikatzetz ha'yisrael ba'atzmo di'yehu ha'gozel, ela yikatzetzenu ha'akum v'hu yimsor liyad Yisrael v'yikna Yisrael osam l'idei yeyu shebiyad ha'akum. And therefore, the proper way to do it is to let the Gentile cut the schach, or to cut the arba minim, and then to give it to you. And you can buy it from him or let him give it to you as a gift. But as long as he's the one that's cutting it from the real estate, he's the one who's the ganaf, and therefore by the time it gets to your hands, there's already been yeyush, and now it's changing hands, and so therefore it's legal. V'shini rishus shebiyado ayin sham. Al kol panim muchach misham da'afilu bistam chayshin shlote mitzvah ba be'avera ach kol zeh lechatchila. But this is all lechatchila. Aval b'di'evet lo machmirinan bazeh demisfeika lo chayshin legazula. But the Mishnah Berurah says that b'di'evet, if you did cut the schach yourself or the arba minim yourself, you're allowed to use it. The imgam bizmanenu tzarich lahakbid al zeh ayin sham bebir halacha diver masl ba'atzmo shari tshuva sham sifkat and beis. He says the poskim there deliberate whether this halacha even applies in the modern era. Like the Mishnah, even in the times of the Mishnah Berurah, he equivocated whether this halacha really still applies anymore, where there are legal titles that are drawn for these kinds of things. So Siman Taf Reish Mem Tes. Taf Reish Mem Tes. In the Bir Halacha, let's see. Let me just see which Bir Halacha he's referring to. Divrei Maschil Ba'atzmo. Okay. All right, I'll have to take a look at this Mirz Hashem for next week. We're not going to be meeting next week until Wednesday, Mirz Hashem, because of Yantif. So we will, Mirz Hashem, continue this discussion next week. Okay, is that all right, everybody? Let me wish you not only a good Shabbos, but a good Yantif, and it's Hashem. We will continue this. Comments, questions, anything? Okay. All right. Chag Sameach, good Shabbos, and Chag Sameach.